Your Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Armed Forces, my Lady, the Chief Justice of Kenya and President of the Supreme Court of Kenya, distinguished guests, allow me to adopt the protocol list as earlier given. Your Excellency, we are greatly honored by your presence at our ADR summit today, and we thank you profusely for taking time out of your very busy schedule to grace the summit. Our goal as the Africa Chief Justices ADR Forum is to make litigation the last resort, not a first response in resolving disputes. Our hand in this regard has been held by some cooperating partners, and these include Pepperdine University of the United States of America, who have journeyed with us right from inception, and the Chandler Institute. Allow me, Mr. President, to ask the Vice President of Pepperdine University, Dr. DeWatt, as well as Mr. Ron Chari from the Chandler Institute, to just stand. They are our partners. Please sit. By gracing this summit, you are sending a very clear message. Africa must choose to dialogue over delays. Governments, judiciaries, legal practitioners, and disputants must now walk through that door together. We want to make ADR the first door citizens knock on, not the last, because every case that clogs our courts is a business delay, a farmer unpaid and the family divided. With alternative dispute resolution, we shall unclog the arteries of justice. To be clear, ADR does not seek to replace the rule of law, it seeks to strengthen it. It does not undermine the judicial function, it complements it. Mediation, arbitration, negotiation resolve disputes faster, cheaper, and leave relationships intact. These ADR mechanisms are not soft options. They are strategic tools. They keep African business running instead of litigating. They keep foreign investors confident that contracts here in Africa mean something. They keep communities together and instead assist in ensuring that they are not torn apart by battles in court. For Africa, it means much more. Investors have confidence, small-scale and medium enterprises survive cash flow shocks, and our courts can focus on matters whose nature or complexity truly need a judge's attention. Africa's clarion call is to move from aspiration to execution. Africa's development agenda will not be delivered by declarations alone. It will be delivered by institutions that turn political ambition into commercial trust, cross-border investment, and enforceable justice. And so we meet today at a definitive turning point. The continent has set its grand ambition. We have negotiated historic treaties, committed to regional integration, industrialization, and embraced the promise of self-financing. Yet Africa's execution agenda is mathematically impossible without the deliberate institutional integration of our judiciaries. Development depends on capital, and outlay of capital demands confidence. Confidence, in turn, cannot exist without justice, capable of protecting rights, enforcing contracts, and resolving disputes predictably. This reality underpins the Africa Continental Free Trade Area. The Africa Continental Free Trade Area is not a passive trade agreement. It is the economic vehicle for Africa's sovereignty. But let us be clear. Protocols do not move goods or services. Treaties do not de-risk capital. Investors will not commit capital to an integrated market unless they trust that cross-border disputes will be resolved fairly, transparently, and swiftly. Judiciaries are not peripheral observers, as we have already heard, of development. They are its primary infrastructure. And when we discuss trade, infrastructure, our minds turn to physical, assets. We shall think about highways, deep water ports, standard gauge railways, and the fiber optic networks. But an integrated market requires a parallel foundation, the infrastructure of trust. And this invisible infrastructure is built by courts, commercial registries, alternative dispute resolution mechanisms, and alternative justice systems. And let me briefly quantify the cost of institutional failure. First, delayed judgment is as economically destructive as a delayed shipment. An unenforced arbitral award undermines investor confidence as deeply as a collapsed bridge. A fragmented, unpredictable dispute resolution system acts as a non-tariff barrier, as any illegal border closure. So for this reason, investing in commercial courts and ADR is an explicit investment in Africa's global competitiveness. Modern commerce requires justice to be fast, predictable, and digitally integrated. ADR and AJS are no longer elite options to formal litigation. They are central mechanisms for delivering justice. They preserve commercial relationships, slash transaction costs, and democratize access to justice for small-scale cross-border traders, women entrepreneurs, and multinational investors alike. However, we must ask candidly unsettling questions. Is ADR truly operational within our judiciaries, or is it merely present in law and policy? This summit, Mr. President, rightly asks whether court-connected ADR is functioning as a trusted tool, or whether it remains present in law but weak in practice. That question must guide our deliberations. Africa has no use for symbolic ADR designed for compliance metrics. So, what is the ADR Africa needs? A, Africa needs operational ADR. B, Africa needs credible ADR. C, Africa needs ADR that market actors, regulators, courts, and investors can trust. And this brings us back to the core mandate of this summit, judicial alignment. Our judiciaries must be present where Africa's development architecture is designed, financed, and monitored. The Africa Continental Free Trade Area is creating a single continental market, stretching across diverse legal traditions, constitutional limits, and varying levels of digital readiness. This diversity is an asset. but it must be allowed to develop into systematic, it must not be allowed to develop into systematic fragmentation. If an international trader or investor encounters inconsistent enforcement, weak mediation platforms, or analog case management across borders, the entire promise of regional integration weakens. So judicial alignment does not demand the erosion of national sovereignty, identical statutory laws, or uniform courts. Rather, it demands shared operational baselines and common enforcement standards, mutual recognition of cross-border settlement and of arbitral awards, discipline and efficiency in automated commercial case management. It also calls for judicial predictability, secure tax certainty, and support robust domestic resource mobilization. This is the strategic value of the Africa Continental Free Trade Area. Judicial alignment roadmap. It establishes the baseline for cooperation and mutual confidence required to make a single continental market functional. That combination should not remain at the margins of this summit. It should be embedded at the center of our discussions. Your Excellency, Your Excellency has consistently, in fact, challenged Africans to finance their own transformation. And this challenge applies equally directly to the administration of justice. Judiciaries provide the baseline credibility and stability for fiscal systems. And by making tax rules predictable and resolving revenue disputes fairly, our courts enable governments to mobilize domestic revenue without choking the private sector growth. If justice is infrastructure, governments must finance it as infrastructure. Governments must invest in commercial courts, digital case management, ADR processes, judicial training, enforcement mechanisms, and user-centered justice services. Africa cannot invest billions in physical infrastructure while neglecting the justice ecosystems that protect the contract sustaining that very infrastructure. This is where the African Chief Justice's ADR Forum has a vital role to play, because it is uniquely positioned to transition the continent from fragmented, isolated judicial reform to a coordinated continental network. The theme of this summit, a justice system that serves, listens and resolves, advancing ADR and alternative justice system for peace, inclusion, and prosperity in Africa, must look beyond professional networking. The African Chief Justices Forum, ADR Forum, must be leveraged as a strategic continental enabler. If Africa is serious about economic transformation, its judicial leadership must sit at the main table where development priorities are budgeted, delivered, and evaluated. Distinguished colleagues, Africa's economic future will not be secured by declarations alone. It will be secured by institutions that execute. The Continental Free Trade Area requires roads, ports, energy, finance, digital systems. But above all, it requires courts that can be trusted, ADR mechanisms that are credible, settlements that are enforceable, and judiciaries that are aligned around the realities of a united African market. Your Excellency, the leadership of Africa collectively can make ADR the default, not the alternative, by supporting court-annexed mediation and general mediation, enforcing arbitration agreements, and mandating ADR clauses in government contracts. We will not just reduce case backlog. We will build a culture where Africans go back to resolve their problems at the table with speed, dignity, and wisdom, not only in the courtroom. A nation that resolves disputes wisely grows wisely. Let us choose dialogue over delay and settlement over strain. And may Africa be known not just for the disputes we have, but for how wisely we resolve them. So, Mr. President, we ask for your hand in this. Champion the enforcement of arbitration clauses in government contracts, support court-annexed mediation, champion ADR in every ministry, and with your voice behind it, ADR will move from margins to the mainstream. So let this summit send an unequivocal message to the continent. Jurisdictions are development institutions. Judiciaries. Judiciaries are development institutions. Justice is infrastructure. ADR and AJS are the primary tools of delivery. For Africa to trade with confidence, invest with courage, and grow with true inclusion, we must resolve our disputes with fairness, speed, and absolute trust. This is not a narrow technical adjustment. It is a development imperative. And that is our responsibility. That is our historic opportunity. And that is the precise work before us. A strong Africa is not one that litigates more. It is one that resolves disputes better. Mr. President, I thank you very much for listening.